Hi everyone, Jai Hind and welcome to the platform of StudyIQ IAS in English. My name is Bhavar Singh Surem, ex-NDA 115th course and qualified civil services in 2012, and I welcome you on the platform. Now in this session, we'll be talking about a very immediate issue that had been raised after the Supreme Court have, set aside the order of the Gauhati High Court. I'm talking about the Assam citizenship crisis amid the recent remark that had been made by the Ministry of External Affairs about the passport as well. So this is quite important because this issue, it pertains to your prelims, to your mains as well, and again, it pertains to the ethics and essay papers also. Now, when I'm talking about this news, this is about the Supreme Court which have set aside the order of the High Court which upheld the Foreigners Tribunal ruling against the 27 of the residents. Now, over here, the Supreme Court have said that these cases, they remanded fresh adjudication. The Supreme Court have over here not ruled on the merits of the citizenship itself, and that is why this is again very, very important that Supreme Court have not said anything about citizenship, but it has said that there are the fresh adjudication that must be made into these cases. Now, over here, the court have stated that the process that should be followed at the Foreigners Tribunal, that must be fair, lawful and reasonable as well, and there should be the statutory. When it comes to the statutory burden of the proof, this is quite important because when it comes to the Foreigners Act of 1946, it's section 9, it actually lays down the burden of proof onto the individual and not onto the state itself. This is also important because the state's legitimate interest in preventing the fraudulent citizenship claims, it was also explicitly acknowledged by the Supreme Court while giving this verdict. So we'll be moving ahead and we'll be going towards the complete deep analysis of this issue. But before that, let me tell you that on the platform of StudyIQ, we are offering you with the lowest price, and ultimately you can use the code that is BRS Live for the maximum discount that you will get on the platform of StudyIQ itself. Now this is quite important because when it comes to the Foreigners Tribunal, so it was in 2019 that when it comes to this case particularly, so there is a Foreigner Tribunal number 4 that is there in Kamrup Metro, which have declared the resident foreigners on the documentary grounds itself. Now, there was an appeal that actually lied in the Gauhati High Court, which have upheld the tribunal order in the multiple writ petitions, and there were the 27 of the appellants. They had moved to the Supreme Court challenging the High Court's affirmation. Now, this was on 13th of July that the Supreme Court have set aside the High Court order, reminded that the case should be filed for the fresh adjudication in the High Court itself. Now, this is quite important because before, understanding this complete procedure and what we are going through, we should go through some of the words which are quite important for understanding the complete issue. The first one is the Foreigners Tribunal. Now, when it comes to the Foreigners Tribunal, please remember that this is a quasi-judicial body that had been, mandated under the Foreigners Tribunal's Order 1964 that actually adjudicates whether an individual is a foreigner, and this is unique to the Assam citizenship regime. Then there is section 9 of the Foreigners Act 1946, which actually places the burden of proof onto the individual itself and not onto the state. That is once the question of the nationality that had been raised, or the question of the citizenship that had been raised. I'm sorry, not nationality, but the question of the citizenship that had been raised against an individual. So then he has to prove himself that he is citizen of India. And then there is D voter as well. Now, D voter is basically the doubtful voter, a category marked on the Assam's electoral roll since 1997, pending the citizenship verification, and they cannot vote until they had been cleared as well. Now, there is also NRC or the National Register of Citizens, where it is basically Assam's list of verified citizens, which was updated between 2015 to 19. The final draft, it had still not been endorsed by the Registrar General of India. And then we have 1971 cutoff. This is quite important that the 24th March 1971 was taken as the cutoff as per the Assam Accord that was signed, and anyone who have entered after this date is treated as the illegal migrant regardless of the rest of the India's cutoff as well. And there is statutory burden of proof. Now, when it comes to statutory burden of proof, this is basically the legal requirement that the person questioned must furnish an unbroken documentary chain, not merely to assert the citizenship. So there has to be a complete, the burden of proof. There should be an unbroken documentary change that must be, it must be justified by the individual against whom the case has been lodged for or in the Foreigners Tribunal. Now, there is another important vocabulary, that is legal fiction. Now, when it comes to legal fiction, it is basically a status which had been created purely by the law and not by the nature. I'll come to this why I'm talking about the legal fiction, because ultimately, unlike nationality, so nationality is basically a fact of the origin, where you originate, where you take the birth. But when it comes to citizenship, citizenship is basically a legal fiction which had been created by the Citizenship Act of 1955 in India. Alright, so citizenship is a construct of the state that defines it, and it can also withhold your citizenship. Then there is nationality, which is a factual acknowledgement of where a person is from recorded on his passport, not itself proof of the citizenship in the legal sense also. Then there is also the documentary chain of evidence. Now, documentary chain is basically where we have an unbroken sequence of the admissible records linking a person to an ancestor who had been listed before 24th March 1971. That is basically the cutoff date. In Assam, there is IMD as well, illegal migrant determination, which is the process under the IMDT. Now it is under the Foreigners Act, ultimately for classifying and acting against those who have entered India unlawfully. There is also family tree matching. Now, when it comes to family tree matching, it is where the NRC verification mechanism has been laid down for cross-checking the applicants against the ancestral legacy data. Now, legacy data is where it is matched and alleged to have been compromised during 2015-19 during the NRC process. There is also evidentiary value. The evidentiary value is where we have the legal weight a document carries in the proceeding. The legal weight that it has, whether it is the Aadhaar or it is the PAN card or the EPIC. So they establish the identity or the residence, but courts hold that they don't establish the citizenship also. So again, this raises a pertinent question that was raised even earlier, that what actually or which document actually they are, or they are for the citizenship, or they prove the citizenship of India. Now, there is statelessness as well. Now, when it comes to the statelessness, so this is where a person, he is not you can say citizen of any of the state. Alright, so this is where this is a condition of not being recognized as a national by any state, and that leads to the problem of the statelessness, which is a possible real world consequence of the failed citizenship proceedings as well. Now, there is the ILP, that is basically a travel document regime for the select northeastern states that restricts the outsiders' entry there, and this is a parallel mechanism for regulating the outsider anxieties. And then we have the Assam Accord, which was signed between the Centre, Assam government and ASU, that ended the 6-year Assam movement and ultimately set aside the 1971 cutoff also. There is also SIR process which is being under process in the northeast region. Like for example in Manipur, and the election commission exercise for re-verifying the electoral rolls across the multiple states, that is currently in progress in Assam and in Manipur also. There is also refoulement. Now, refoulement is basically the international principle or law principle against returning a person to a country where they face the prosecution. This is relevant for the any of the deportation debates that could be there. And then there is jus soli and jus sanguinis. Now, jus soli is by birth or by birth on the soil, and jus sanguinis is by the descent. Now, when it comes to India, so in India we had the citizenship that was basically governed by jus soli principle, that is, if you are born in India, you will be termed as the Indian citizen. But now we have moved towards the jus sanguinis after 1986 Amendment Act that was done into the Citizenship Act of 1955, and now we follow the principle of the citizenship that would be by descent. So these are the important terms, that just keep them in mind and now move ahead and understand the complete process. Now, over here it is quite important that you must have heard about the June 2026, where on 24th of June, that is the Passport Services Day, a spokesperson from the Ministry of External Affairs have said that ultimately the passport alone, it cannot justify a claim to the Indian citizenship. Now, when it comes to the various documents which are there, like for example, we have Aadhaar, we have PAN card, driving license and voter ID as well, they cannot also be assumed as the solid proof of citizenship by the courts. And the public bewilderment over here is that if none of these documents they prove citizenship, then what does? And that is a question that the government must answer. Now over here, the retired Supreme Court Judge Madan Lokur, he also publicly contested the Ministry of External Affairs position, and he have said that a passport is a legal proof of the citizenship. Now, this speculation follows that the center may create a distinct NRC endorsed citizenship document, but let's see that when this will come into the light or into the picture. Now, the confusion is that the passport actually records the nationality, or that is from where you are. And it is not a legal proof of the citizenship. That is a status that is defined by the law separately, and it can be disputed. So ultimately over here, most of the countries, they treat the passport the same. That is, it is a proof of the nationality, but not proof of the citizenship. And India is not an outlier here. So this has not to be contested. So this is what I was talking to you about. That when it comes to nationality is the factual acknowledgement of your origin, and it is recorded on the passport for the international travel. Historically, it was basically issued without the strict citizenship checks, because passports, they predate the universal citizenship regimes and does not by itself carry the legal proof value in the Indian courts. And there is a provision as well in the Indian Passport Act where the Indian passport can be issued to a foreigner as well. So therefore, it is aptly said that the passport itself, it cannot be a proof of citizenship. Now, when it comes to citizenship, this is a legal fiction that I was talking to you about, where it is a status entirely created and defined by the law. It is not equal to the nationality. Now, this had been established through the Citizenship Act of 1955 and the subsequent amendments which had been done, and proven only through an evidentiary chain the law recognizes. Now, this can be contested, this can be reviewed and revoked by the legal process, unlike the fact of origin or nationality that you have. So over here, it is quite important that when it comes to Assam, why we have the citizenship crisis over here. So this was between 1979 to 1986. This was a 6-year period where there was an agitation that was led by ASU, or All Assam Student Union, against the unchecked migration that was there from Bangladesh. Because ultimately in 1971, Bangladesh got liberated. And when it got liberated, so there was the refugee influx into the Assam that have led to the sharp rise in the electoral rolls after 1971 war. And over here, there was a central fear that was articulated. Now, this central fear is the central fear for the northeast India, the complete northeast India, and that is that there could be Bengali-speaking migrants swamping the Assamese-speaking natives, altering the complete demographic and the political balance as well. Now, over here, this moment partially resolved through the Assam Accord that was signed on 15th of August 1985 between the Centre Assam government and the ASU, and the accord set the framework still governing the citizenship dispute that is there in Assam even today. So this is quite important that these are the key accord provisions which were struck. Now over here, it was said that foreigners which have entered before 1st January 1966, alright, they will be regularized as a citizen. Now, those who actually entered between 1966 to 1971, so these will be the citizens, but then they will be disenfranchised for 10 years. And those who have entered after 24th March 1971, they had to be detected and then they have to be deported and deleted from the electoral rolls as well. So these were the key provisions that were stuck in the Assam Accord. Now there is clause 6 of the Assam Accord that actually says, or it actually promised, the constitutional and legislative and administrative safeguards for the Assamese people's cultural, social and linguistic identity. Also, the implementation remains a live political demand for the clause 6 of the accord, which is a high-level committee has also examined it in the phases since the Assam Accord had been signed in 1985. Now, there is Citizenship Amendment Act that was done in 1986. Now, over here, this is again, when it comes to this amendment, please remember this, that why this was triggered. This was triggered because of the Assam condition itself, where it ended the unconditional just solely principle. Alright, where there was the birthright citizenship that was provided for those, they were born before this amendment. And ultimately, it introduced the stricter just sanguinis link conditions where birth alone, it no longer guaranteed the citizenship in India. There is direct legislative fallout of the Assam Accord's push for the stricter migrant identification, and that have pushed the central government for bringing this Citizenship Amendment Act in 1986. Now there is the NRC which was updated between 2015 to 2019, and over here how it was meant to work was that there is the legacy data that was taken. Now this legacy data was basically where we had the 1951 NRC data along with the electoral rolls that were taken up to the 24th March 1971. Now this was basically the base reference or the base data that was compiled. Later on, there was the application where the residents, they submitted their documents linking themselves to the legacy person which was basically in this legacy data. Then there were the instruments or the software which actually cross-verified the claimed ancestral linkages against the legacy records, and then the final draft that was published in 2019 which actually excluded roughly 19 lakh of the applicants statewide. Now, when it comes to this NRC update, this also, it went into the kind of controversy or the failures. The failure were on two fronts. It was basically the financial and the procedural failures that we are talking about. Because the final draft that was published in 2019, it was in the controversy related to financial mishandling and even the alleged accommodation of the illegal migrants as the original inhabitants into them. So as of today, the draft, it actually remains unendorsed by the Registrar General of India and it has no legal finality. And even the CAG have flagged that there had been irregularities to the tune of 260 crore rupees during the updating process and recommended a legal action as well. Now here again, when it comes to the right now, the Chief Minister of Assam, Himanta Biswa Sarma, so he has also publicly acknowledged that NRC is the faulty or it is as faulty and warning that it could jeopardize the complete national security and harm the indigenous interest as well. So over here, when it comes to the NRC, the process was completed in 2019, but the process or the complete data, it actually had not been endorsed by the RGI or Registrar General of India. Now there are two different contrasting track that you can find over here. When it comes to the Assam Accord, so there is the NRC or the Foreigners Tribunal regime that is there in Assam, and there is a Constitutional Amendment Act that was made in 2019. So over here, there are two regimes which actually pulls in the opposite direction. One restricts and the one relaxes, which actually makes the complete current citizenship framework internally contested. So over here, when it comes to the NRC or the Foreigners Tribunal regime, so here it detects and removes the suspected non-citizens, but the Citizenship Amendment Act of 2019, it granted the fast-track citizenship to the specified prosecuted minorities. Now over here, who have been targeted by the NRC or the Foreigners Tribunal regime? Anyone unable to prove the citizenship regardless of the religion. But here, it is basically the Hindus, Sikhs, Buddhists, Jain, Parsis and Christians which have migrated to India from Pakistan, Afghanistan or Bangladesh. They were fast-tracked for the citizenship by the Amendment Act that was brought in 2019. Over here again, it is quite important that the cutoff was taken as 24th March 1971 by the Assam for the Assam, and here the cutoff was basically for the national purpose. It was 31st of December 2014. And also ultimately the net effect on Assam was that it had tightened the scrutiny on residents lacking the documents, and it had created a religion-based exemption path which have sharpened the citizenship debate further for the Assam and the other regions where we had the migrants which have flowed. So ultimately this is quite important that when it comes to the Citizenship Amendment Act of 2019, it is or it does not applies to northeast states. Alright, to any of the northeast states, we do not have this amendment that was made in Citizenship Act. It does not apply to any of the northeastern states. That has also to be kept in the mind as well. Now, when it comes to the legal proceedings, so there was a case that was there in 2005, which is Sarbananda Sonowal versus Union of India, which have challenged the illegal migrants determination by the Tribunals Act of 1983. Now, which applied to the Assam alone, and it has placed the burden of proof on the accuser and actually not on the accused. So over here, the three-judge bench, the Supreme Court bench, it has struck down the IMDT Act and its rule as unconstitutional, and it has held that it violated the Article 14 and Article 355 as well. Now, this has mattered because the conviction rate that was there under the IMDT Act was under 0.5%, and court called it the biggest hurdle to the deportation as well, and directed that the Foreigners Act of 1946 and Section 9, where the burden actually shifted to the individual itself. So over here, it had directed that there should be the foreign tribunals that should be, made, and it should be applied uniformly to Assam. That was laid down in Sonowal judgment in the previous one. Then there was a second judgment, or the second case, that was in 2007. And here in 2006, what had happened was Center had issued that Foreigners Tribunals Amendment Order. And it had made the Journal 1964 order inapplicable to Assam and created another separate order, that is Foreigners Tribunals for Assam Order 2006. Now this was again challenged before the Supreme Court. And over here, Supreme Court have held that 2006 carve out the violated Article 14 and 355, and thereby it was struck down. And Union government was directed to constitute the sufficient foreign tribunals within 4 months to clear the backlog that was there. And the backlog that we are talking about is that there were 14,947 cases which were pending before the foreigners tribunals as of December 2005, and there were 29,429 of the person which basically entered into Assam between 1966 to 1971. They had been identified as the foreigners under this regime, and thereby this was challenged in the Supreme Court. So now over here, how this complete Foreigners Act it works, or how the complete machinery works. So over here, this is a colonial law era, or era law that you can say, and ultimately it is to regulate the entry, presence and even the departure of the foreigners in India. Now when it comes to the complete law, it applies nationwide, but it operates distinctively in Assam through the dedicated tribunals which are there. Now, what happens is that if there is any suspicion raised about the citizenship of any person, so then there is a reference that is made to the Foreigners Tribunal, then it moves to the burden that is shifted onto the individual. As per the Section 9 of the Foreigners Act that is there in 1946, and then the tribunal, it gives the opinion, and then there is the appeal that could lie to the High Court or the Supreme Court. So critically, when it comes to the criminal law in India, you can see that the presumption is that the burden of proof that is on the accuser. Alright, the burden of proof is onto the another person and not to the person who had been accused. So this is quite important, that when it comes to the Foreigners Act of 1946, it actually creates the burden of proof onto the individual itself, that you must remember for your complete framework. This is quite important, that when it comes to the complete Northeast region, so whether it is the clash that we have seen in Manipur, or whether it is about the Assam citizenship issue that is there, so we have seen that when it comes to the complete issue, it is about the preservation of the culture, the preservation of the land rights, that is, or that has always led to the various, you can say the violence, the various, protests that we have seen in Northeast region. Now there is the 6th schedule that is actually there in the Northeast region, that actually protects, or it actually gives the autonomous district or the regional council in the 4 of the states. That is, we have Assam, Tripura, Meghalaya and Mizoram, and it protects the tribal land, customary law and the local self-governance from any kind of outside encroachment. It reflects the same underlying anxiety that I was talking to you about in the Northeast region, which is about protecting the indigenous identity from any kind of demographic change in the Northeast. Now there is also inner line permit, or ILP, that is there, and this is colonial origin, a travel document regime that restricts the outsiders' entry into Arunachal Pradesh, into Nagaland, into Mizoram and Manipur as well. Now when it comes to Manipur was originally not under the ILP or inner line permit, but it was brought under ILP in 2019 because of the of the Citizenship Amendment Act that was made in 2019, and ultimately this was again because of the demographic anxiety that was raised in Manipur. Now this shows the region-wide pattern that is there, that is legal gatekeeping is a response of the migration fear that we have seen in the Northeast region. Now this is quite important, that when it comes to this person, that is Aminul Hoque, you can see over here that this is the kind of the situation that we are dealing in Assam right now. Now he was the resident of Hajdoba village, which is in Golpara, and he had been declared as a foreigner despite submitting 15 of the documents. Now he had claimed that family originally lived in Charai Khasra village, that is in Lakhipur PS of Golpara, and the names of the father and the grandparents, actually they appeared in 1951 NRC. Now there had been recurring Brahmaputra river erosion which have forced, or it has forced him to relocate to Domakura village. Now Over here, again, the grandparents, they appear in 1966 and 1970 electoral rolls. Now, family later separated, where the parents, they actually moved to Gugudoba and finally to Hashdoba as well, where actually Huck was born in 1988. Now, his own name first appeared in the electoral roll only in 2015. Now, this late entry was basically which have drawn the scrutiny about his claims that he is the resident of Assam or not. Now, over here, sorry, the Gujarat High Court Division Bench, it has dismissed his writ petition and affirmed that there is basically the 2019 opinion that was given that he is basically the foreigner that was upheld by the court. And even the court held that he failed to establish an unbroken documentary evidence or the chain across the generation despite the family's multiple relocations that were there. The court have held that minor spelling variations, they were not the issue, but the court explicitly said that such variations are common and did not decide the complete case. What proved the decisive is basically the gap in continuous admissible linkage, and it was actually not fraud, not inconsistency, just an incomplete chain that have led to this decision that ultimately he is a foreigner and he is not the Indian national. Now, this is quite important because this shows us the lesson that the Aadhaar, the PAN card and the EPIC cards, that is the voter ID cards, they were held to have the limited evidentiary value. And they have established the identity or residence, but again, they have not identified or established the citizenship. Only the pre-1971 ancestral chain counts as the decisive proof when it comes to the citizenship battle in the Assam region. Now, this is what I'm talking about, the unbroken chain that actually requires that there should be ancestor who should be in 1951 NRC or the pre-1971 roll. Now, there should be a document that should link it to the next generation, and then it should link to your parent, and then it should link to you itself. So this is one broken link, and this is an erosion force move, an unrecorded family separation, a name spelled differently across decades, and if the chain fails, regardless of how many modern documents a person holds, then you will be declared foreigner when it comes to Assam. Now, there is D voter as well, that is doubtful voter, which is the efficient flagging, but then there is the opaque relief. Now, this was introduced in 1997 to mark the electors whose citizenship is doubtful. They cannot vote until they had been cleared by the tribunal. Now, there are more than 1.5 lakh individuals which have carried the D-voter tag at various points since the inception past ECI or the state disclosures. Now, there are the strength where actually it flags the disputed cases early before the elections, and it prevents the disputed voters from casting their votes into the elections. And ultimately, judicially, this is reviewable through the tribunal and the courts as well. So these are the strength of the D-voter category that actually exist in Assam only. But at the same time, there is no fixed timeline for the tribunal resolution, and the status it can persist for years. This also marks itself can trigger the social stigma before any adjudication, and historically it had been used disproportionately against one linguistic religious group. That is its quite weakness that we are talking about. Now, this is quite important that when it comes to the citizenship dilemma, this impacts the gender, or you can say women, and or even the class battle also. Because when it comes to the women, they are more exposed. The married women, they often move villages. They change their surnames after the marriage as well, and their addresses, and that breaks down the documentary chain further. Historically, there had been lower rates of the independent land ownership or the school records in their own name, and the oral testimony that is from the women relatives that has in some cases been weighted less by the tribunals as well. And then there is the class struggle as well. I'm talking about the poor families which are less likely to have retained the decades old paper. So ultimately they are more vulnerable to such instances, and there is the legal aid and documentation cost as well. So these are already poor, and how they will support the legal aid and the documentation cost, which actually is the financial burden on the poor and the vulnerable classes. There is also Char or Chapori, the riverine communities which actually lives in the Assam. So they are among the Assam poorest, and also they are also the most erosion displaced, and thereby there is a fear of the evidentiary chain of value, or the chain of the complete command that is to be proved. And that evidentiary chain, if it gets broken, so ultimately they would be flagged as foreigner, and then they will be left as stateless. So that will be all in today's session. I hope that this matter is clear to every one of you. Let me remind you once again that we are offering you with the lowest price that you are getting today. And this is for all the courses which are available on the platform of StudyIQ. What you need to do is you need to use the code BRS Live, so that ultimately you can get the maximum discount that is available on the platform of StudyIQ at that point of time. So that would be all in today's session. Thank you very much, guys, for joining me over here on the platform of StudyIQ. I will see you in the next. So till then, please do not, please do take care of yourself, and also do not forget to like the session, and do like the session, even do share the session with your friends, and also subscribe if you have not subscribed it yet for the future updates. Thank you, bye bye, take care, and Jai Hind.